Speaking of, okay, so this is a disjointed segue because I need to understand this. It's been in the news. People have been going nuts. The Texas, are we going to get, we might get demonetized for the words, but we can't. And I'm not going to say shmushmorshin the entire time. What movie was that? 40-Year-Old Virgin or
The
not?
Texas medical procedure law.
Well, I'll refer to it not to be the total coward, and then we're going to just refer to it as a medical procedure. The Texas abortion law, which it's an interesting thing because I've been looking into it. I'm trying to make sense of it. The bottom line now is that Texas has enacted a law, a state law, that would prohibit the procedure as of 6 weeks. 6 weeks is from what I understand and from what I can see.
As soon as a heartbeat can be detected,
okay, sorry.
Which is usually translated 6 weeks, but not always.
Okay, so I didn't mean to misrepresent. So it's the heartbeat law, which means as soon as we detect a heartbeat, precluded from the procedure, typically around 6 weeks, which would make it, unless I'm mistaken and misinformed, the earliest prohibition in the world. They passed the law.
In America, there's still countries that ban abortion.
Okay, that I should rephrase that. Of the countries that have abortion laws, this would be the earliest because typically by the World Health
usually it's the 12th week or 13th week that a lot of countries ban it.
So the state imposes this law. It passes this law. It goes through the legislative assembly. It does it the way democratically elected governments are supposed to pass laws democratically. SCOTUS 5-4 says we're not overturning it. Now, this is where I'm not sure I understand the rationale. Are they saying procedurally? I guess I don't understand how they say we're not overturning it, given the precedent of Roe versus Wade. So, what's the rationale for SCOTUS not overturning this law?
So, what's unique about this law is two things. One aspect's not that unique, in that other states have looked at passing heartbeat bills. Whether that's 6 weeks, 8 weeks, 10 weeks, that can vary. Sometimes it's considered, but the earliest heartbeat can be detected typically at 6 weeks. I think the norm is more like 8 to 10 weeks. But putting them, that side aside, the key to this law is that it is only enforceable by private lawsuit. No government actor can enforce the law. So it doesn't make it a crime. You can't be suspended from medical practice. You can't be fined. None of that. The only people who can enforce it is private citizens bringing a civil suit on the grounds that you did an abortion when the fetus had a heartbeat.
Okay, and then let me stop you there, because that's the part that I didn't understand, is that this gives a legal interest to a private citizen. It gives a legal interest
and a new cause of action.
But how do you cause of action being that the plaintiff, in theory, could have no relation whatsoever but knowledge of the fact that a defendant is seeking the procedure, and they now have locus standi to file suit. Yep. I don't know how is that legally tenable, even if you agree.
It's kind of like private attorney general actions. It's just removing the state actor role. So citizens, for example, can sue ketam cases against various fraudulent actors and profit from it as if they're a private attorney general. A lot of civil rights suits are considered de facto private attorney generals. So what they've done is effectively created a civil rights suit where any individual can file suit against anyone else who does this procedure, and has given them broad standing to obtain that. And so it was a smart way of creating the suit, in my theory, in my view, because the problem was then the people who sued, the various abortion care providers and pro-choice groups, they sued the state actors, and the state's point was, we don't enforce this law, so you can't sue us. You can raise this as an affirmative defense, which the law allows for. You can raise this as an affirmative defense if anybody sues you, but that's the only way you can resolve this. They didn't like that. So they asked the district court to declare the law illegal and to enjoin it. The declaration action is still pending. They do have a right to declaratory relief, but they wanted to stop it from even being enforced while the declaration relief was pending. The district court said there's nobody to enjoin because this is a private cause of action law. It's not a state actor law. Fifth Circuit said the same thing. So it goes to the U.S. Supreme Court, and the U.S. Supreme Court splits 5-4 on the injunction aspect. And what they don't say that the substance of the law is good or bad. All they say is here there's no we don't have a power to enjoin anybody when nobody has the power to enact this. and you have the option of other than private citizens. We can't. How are we supposed to enjoin the governor when he has no enforcement power? So this is why the law was written the way it was. It was written so that you could not enjoin it, and what they really want to do is force it through the Texas state court system, and have the Texas state court rule on whether or not it's constitutional, and then get up to the U.S. Supreme Court. So they've designed a system to create a new procedural remedy that creates a legal hurdle for the people suing. And I think the Supreme Court was right. I mean, to me, it should have been 9-0, because the three Democratic justices, and unsurprisingly Roberts, would have enjoined it, even though there was nothing to enjoin. I mean, that's the problem. It's like you don't enjoin a law, you enjoin somebody enforcing the law. That's how federal courts have jurisdiction over state government actors. Otherwise, they're immune from suit. And now that's one immunity in the federal courts, I think, is correct, because I think they should be suable in the states, but not the federal courts under the Constitution, given the balance of power between the two. And so that, to me, it was like a no-brainer decision. I get why it was controversial. It's because the pro-choice people are enraged that the state legislature came up with a smart mechanism that made it tough to sue outside of Texas state court. But that's what they did. That was the right legal constitutional consequence to it. Now, some of the panicked reaction by some people was a little bit overstated, because yes, you can be sued in state court, but the federal declaratory relief action is still pending, and the state court action, you can raise it as a defense in state court. So really, what they're mad at is having to face a lawsuit. But they don't have any problem filing lots of lawsuits against people. So this is, it seemed to me, a logical extension. I think the other thing that's going to surprise some people, the underlying issue, which will be first dealt with in the Mississippi case, is whether the standard should be viability or heartbeat, or whether it's up to the states to decide that standard. So right now, the standard has typically been whether or not the baby can survive outside of the womb. There's a lot of reasons why that never made a lot of sense from a legal perspective, making that the medical standard, and said that you could not prohibit abortions for the most part prior to that. The Mississippi case is challenging that. The Mississippi case is saying that that it should be a heartbeat, or it should be up to the states to determine. Viability shouldn't be the sole basis, given the increased medical information we now know. And so there's also another aspect of the Texas case that's being challenged, that's about partial birth abortion and other things. That's also going through the court system as well. But I think that what the Supreme Court did, to me, legally, was the correct decision.
But if they want to challenge the law on the basis that if they want to challenge, I don't know if the word is constitutionality.
I mean, they can still seek declaratory relief. They can't. There's nobody to enjoin, but they can. Their suit against the state government is sufficient for them to get declaratory relief. The court can declare whether that law is constitutional or not.
And that would,
I mean, really, it's about. There's a lot of cases where you're forced to defend yourself in court as to assert your constitutional remedies. They do this all the time in criminal cases, so I don't see why there's any problem with doing it this way in this context, in my view.
And if they were to do that, it would go through the state courts and not through the federal courts to SCOTUS. So they start at the state level, see what the state level says, appeals court, and then I guess there's a Supreme Court of Texas.
Yep, that's exactly right.
Okay.
And what is the Supreme Court of Texas is 7-0 Republican conservatives. So I mean that's why pro-choice people are unhappy. They would prefer federal courts have control than the Texas state Supreme Court have control.
Now they said this overturns Roe versus. The argument was that
it doesn't
this
overturn Roe v. Wade at all. It has no impact on Roe v. Wade in terms of the court's decisions. I mean, the law is attempting to revise Roe v. Wade to apply a heartbeat standard rather than a viability standard, or at least in the alternative, to give states the power to make that choice. Because abortion laws are really two issues. One is, when is there a human life that you have to consider under the 14th Amendment in terms of the fetus or baby, whatever terminology you want to use. And then secondly, who gets to choose? Who has the power to choose? Is that a court decision to declare that, to say here's when it is and isn't? Or is that a state government decision to make? So, I mean, either way, the court, what it does show is that on this issue, there is not, other than Roberts, there is a 5-member majority willing to revisit that question of Roe v. Wade and how it should be construed. So that's going to happen probably next year in the Mississippi case. But all the people saying Roe v. Wade's been overturned, that's not true.
And Roe v. Wade was the principle of Roe v. Wade was that nationally women can choose to have abortions.
I mean, that's how it's been interpreted. I mean, originally it was about doctors. It was about doctors should get to choose whether an abortion occurs rather than the state. They didn't. The court. It was almost quasi eugenics. It was a logic that deferred to the medical establishment. It became a decision that was reinterpreted to mean the right of bodily integrity, which apparently is gone. I mean, people like Bob Reich said unironically, he says, how could people believe that that you don't have a right for that you do have a right of bodily integrity against a vaccine, but that you don't for an abortion? And it's like the logic should go the other way. How is it you have a right to take another life, whatever you call that life, as part of bodily integrity, but you don't have a right to stop the state from injecting something into you? So, I mean, the fact is happening at the same time. The cognitive dissonance is off the charts on the left.
That is what's difficult to reconcile. The distinction is going to be, well, the procedure is not contagious. So, the procedure only affects the woman. Robert, I mean, when I was doing my homework last night and I tweeted the image out, there were people unironically saying abortion saves lives. Now, in a metaphoric sense, I can understand how someone's going to make the argument that like it will save the life of the person who does it because they won't be bogged down with either raising a child or putting a child up for adoption. In the rare circumstances, I can understand where it actually physically does save a life if there's a medical condition for the delivering mom. But I mean, this is where we're entering like unironic levels of irony in terms of language. I forget where I was going with that actually, but the my body, my choice. So seeing the people on the front steps of the Texas courthouse chanting, we want control over our bodies, when darn well, by and large, same people saying you do not have the right to refuse a vaccine, and if you want to, you're shunned from society. There is cognitive dissonance. There is inconsistent application of reason because reason cannot possibly explain away those two mutually incompatible positions as taken. There is a middle ground which is totally compatible, which is choice up to a certain point and then choice not past a certain point, and choice under certain circumstances, but not under others when you can meet a certain evidentiary burden. But here it's willy-nilly. I want the choice here. I don't want the choice there. And you don't get to have that choice.
Yeah. Exactly.
So it goes back down. And so this lawsuit basically, it doesn't go back down anywhere. Now it's file suit at the state level.
It was always at the federal district court level for declaratory relief. So it just goes back to the declaratory relief stage of the case. Okay. And there'll probably be a ruling. I mean, there'll be some evidence and whatnot, but within a few months. So it's going to go back up on appeal, and it may be decided around the same time as the Mississippi case. Either way, the issue of what Roe v. Wade means or doesn't mean going forward will likely get some constitutional adjudication with the new court next year.
All right, we got Jessica Cora with a very interesting avatar. Looks like a Care Bear with something. Something. The reason abortion is such a divisive issue is we are the only country that abortion was settled by the courts instead of the legislature.
Correct.
It's an interesting.
And that was always a problem. And its real origins was deference to the medical establishment, not because they cared one iota about bodily integrity or privacy. So yeah, it became that over time, but that's not what it was when it was first written.
We got this in Canada. It's true. It's not as much of a divisive issue up here because it does not become a political litmus test every election. But it's true enough.